Good day and welcome to the Roads and Bridges Infrastructure Insider Web event. I am John Straw together with my colleague Brad Friend. We are pleased to accept the invitation today to speak to you, extended to us by the Roads and Bridges editors. We'll be covering 4 topics that contractors, owners, subcontractors, suppliers typically encounter when navigating disputes in public contracts and transportation projects. This session is pre-recorded with a live question and answer following. But first, a brief introduction of who we are and what we do. We are partners with the firm Kraftson, Caudle, based in McLean, Virginia, just outside Washington, D.C. But even though we are based here, we've been serving our clients both domestically and internationally at their project sites, their offices, and from our offices remotely well before the pandemic ever started. We are pleased to say that we have worked in nearly all 50 states and several countries around the world. Brad Friend has over 18 years of experience in complex litigation, particularly, for example, with respect to state DOT litigation involving several bridge crossings over environmentally sensitive areas. He's done multiple storm drainage and site work issues for contractors, as well as several bid protests. I have been practicing for over 11 years, and in that time have served a large multi-state heavy civil contractor with several claims both at the state and federal level. I am pleased to be the author of the Roads and Bridges Law column, as well as I maintain a blog at heavyconstructionlaw.com. The two of us, together with our colleagues at Kraftson Caudle, have experience in several different infrastructure projects. For example, wastewater treatment plants, pipelines, airports, both state and interstate highways and bridges, as well as hydroelectric power plants, and last but not least, among the examples, light rail projects, both system upgrades as well as completely new systems. So today we'll be covering 4 principal topics that contractors as well as other stakeholders are most likely to encounter on public contracts and transportation projects. They are claims and disputes, and particularly the notice part of that process, differing site conditions, non-payment, and delays. But first, please understand that these are general principles. We are here to provide helpful to-dos as well as how-tos. Your mileage may vary, so please keep in mind any sort of unique circumstances applicable to your projects. The best roadmap for any dispute is the contract itself. And once you get that contract, particularly if it's with an entity that you don't normally contract, we recommend taking it apart, breaking it down into its individual terms, and understanding what is required of you as well as all other parties to that contract. In fact, just earlier this week, I did this for a client and prepared a terms inventory where I created a key list of all the important provisions with cross-references to the various other parts of the contract, so that that client, that contractor, understands that when a dispute arises or problem comes up, it knows exactly where to go in the contract to figure out what exit to take, what roadway to go on, and how to get there. The contract is your best map. After the contract is formed, there's eventually going to be some kind of a change. Like death and taxes, there are 2 things on any construction contract and project that are certain: changes and to some extent usually delays. The process for navigating those changes is typically a step-by-step process. It's not a Monopoly game. You cannot pass go and go straight to boardwalk or collect $200. You have to go step by step through that process. These changes are always going to occur during the project, and so you have to address them while you're still trying to build the project at the same time. So as we walk through this, let's talk first about changes. There are 2 types of changes principally. There are directed changes and constructive changes. Directed changes are those where one of the stakeholders, typically the owner, typically higher up in the contractual chain, says, I want you, contractor, to do this instead of that. I recognize it's a change. I'll issue you a change order. You tell me the price. That's where the easy changes end. The constructive changes are the more complicated ones. You can even have disputes related to directed changes that are like constructive changes where the owner agrees it's a change but doesn't agree on the price or the time that's associated with that change. A more typical constructive change, though, is where the contractor considers it to be extra work, or the supplier does, but the owner does not. Or where there's a difference of interpretation over some spec, or perhaps there's a defective specification, or even an overzealous inspection by an engineer on the project. Above all, with respect to both types of changes, get it in writing and make sure you reserve your rights. Don't think that simply because you've had a field directive or some kind of on-site conversation or even a meeting reflected in meeting minutes, don't think that that will be enough. Go the steps that are required in your roadmap, in your contract, to memorialize the dispute. That first step involves providing proper and timely written notice. And for a second, let's talk about why this is even important. Of course, it's in your contract and you have to do it. But the key original purpose for notice was to elevate the day-to-day to a higher level importance, to encourage people to pay attention to it so that all parties involved can mitigate damages and mitigate delays. Written notice is above all important. Again, don't think that meeting minutes are going to be enough. Send a letter, send an email. Make sure you do it timely, within a certain number of days of the occurrence of the claim event. And we'll talk a little bit more about that later, but that is important. Know what it is that causes the change and start the clock ticking then. Don't wait too late. It's often even before you begin the disputed work or the changed work. So not only can you recognize a change, but before you even start doing that associated work, send that notice in. Sometimes you have to use magic words, and this isn't always the case in law, but in this case, it's best to say, not only are you giving notice of an intent to file a claim or notice of a change, but you're doing it expressly with those magic words. This is hereby my notice of intent to file a claim. And last but not least, oftentimes the provisions in your contract will require not only that you state that you are going to file a claim, but you have to give some sort of an early estimate of what that cost and time impact will be. Again, that goes back to the original purpose of notice, which is to mitigate delays and damages associated. So a quick story from a Utah DOT project from about 10 years ago. During a pre-pave meeting involving UDOT, the prime, and the sub advised the DOT that typical ribbon paving would be used. And UDOT responded saying that anything greater than a vertical 2-inch difference between active and inactive roadways is intolerable. The subcontractor replied, "We'll use a 5-to-1 shift between the two different lanes." UDOT said that was also unacceptable. Unfortunately, neither the subcontractor nor the prime contractor gave any kind of a written notice until after the project was totally complete and then filed a claim. The board at UDOT denied the claim. In a lawsuit, the lower court ruled in favor of the subcontractor and the prime, finding that even though written notice wasn't enough, UDOT had actual notice. They actually knew that the subcontractor and the prime disagreed over the interpretation of that spec, a constructive change. UDOT appealed to the state Supreme Court, however, and the state Supreme Court agreed with UDOT. The state Supreme Court for Utah looked at a prior case where they had said actual notice was enough, but clarified that actual notice was enough only for a directed change, not for a constructive change. The difference being that in the directed change, the DOT admitted it was a change versus simply a disagreement over how to interpret the specifications. A couple other quick short stories. About 10 years ago in Virginia, VDOT said during trial that it actually had notice of the claim, notice of the change, but nevertheless the state Supreme Court said the contract required written notice. So even though there was admitted actual notice, written notice was required, and the contractor lost that day. Oftentimes contractors don't want to give written notice, because they fear stirring the pot. They want to maintain a collaborative environment. So here's a how-to suggestion. Maintain that list of changes. Everybody has it. Proposed changes, proposed change items, whatever it is. It's some kind of list that you think are changes to the project. On a weekly basis or some other periodic basis, automatically send out a notice of intent to file claim for those issues. Again, depending upon the particular provisions of your contract. Make sure it complies and make sure you're not backing yourself into a corner. Most of the time, however, even if you've given written notice, later you don't have to file a claim just because you've given it. And if you don't want to stir the pot, pick up the phone and call the resident engineer and have a conversation saying simply, listen, I have to do this, my contract says I have to, but I still want to work with you. So you've softened the blow a little bit, but at the same time, you preserved your rights. Past the notice provisions, there's typically a formal change request where you further definitize the amount of the damages that you'll be seeking as well as the time involved. And ultimately, there's a project level decision, which we assume is a denial, ultimately resulting next in a claim. A claim, and when I say claim, I'm talking about a capital C claim, is a formal request or demand for payment or for increase in the contract price or time under the terms of that contract. Again, go back to that roadmap and understand what it says and where it's telling you to go. This type of claim is greater than a typical payment application. It rises to the level like notice does and says, pay attention to me, this is important so we can all avoid further headaches down the road. Something to take away with you, even though this isn't a TED Talk, try the acronym TED. Timing, explanation, and documentation. Timing is critical both in notice and claims. Explanation requires more than just saying, you made me change something, I incurred more costs, therefore pay me. Explain why it's a change and connect the dots to get there. And make sure it's documented properly. Through the claims process, you'll have an ultimate claim decision, assuming it's a denial. Ultimately, for most public projects, there'll be an administrative dispute review board decision, as well as then there might even be a mandatory mediation, which could culminate in some sort of a lawsuit. Again, this is a step-by-step process. You can't skip over one step to get to the next. A mentor of mine once said that processes and procedures can be more important than substance and results. On the one hand, it kind of hurts to say that, but on the other, particularly with public contracts, the procedures are paramount. Even if you have a winning case, if you didn't follow the right steps, you'll never win in the end. Follow the process, even if it appears unnecessary. As I've said to my kids in doing their math homework, make sure you show your work and how you got there. Don't race to the answer. Brad?
Well, thanks, John. I think many of the subjects today are intertwined. John has spoken about contracts and claims and notice requirements. You'll see some of that in my presentation here today. I want to thank John and Roads and Bridges for giving me the opportunity to speak on a couple of these different issues on construction projects today. So I'm going to speak on differing site conditions and delays. And first up, as far as differing site conditions are concerned, we're going to do, like John said, just an overview of those areas. I think you could spend an entire day discussing the legal parameters and issues surrounding differing site conditions, but we're not going to do that today. We're going to provide a general overview of those issues and also delay issues as well. So from a simple standpoint of addressing differing site conditions, I think you have to understand what is a differing site condition. That's the first question that has to be asked. In its simplest form, a differing site condition is an unforeseen condition at the project site. It is unforeseen, it's unexpected, and typically it's not within the scope of work of a contractor. Usually a differing site condition involves subsurface conditions at the project site, but it also can include latent surface conditions as well. My practice is mainly involved in representing site work contractors and roadway constructors. So my involvement has been mainly with subsurface conditions, but at the same time you can have surface conditions in a vertical construction that are differing site conditions, such as mold or mildew, or asbestos, or hazardous materials that are latent in a vertical construction building. Differing site conditions were formerly known as change conditions. John talked briefly about what a change is and what changes are. Formerly, differing site conditions were called change conditions. That was the term that they were called legally. And then subsequent to that, the existence and creation of a differing site condition clause created that term, the differing site condition. Differing site conditions are very prevalent on civil site work projects and transportation projects, and they often cause increases in the cost of construction and sometimes delays. It's something that contractors very frequently encounter, and they need to be aware of differing site conditions that they encounter out on a job so that they can protect themselves and preserve their rights to compensation and sometimes delays and time extensions. So the next question subject I would have is, who bears the risk for differing site conditions encountered on a construction site? At common law, it was the contractor that bore the risk for differing site conditions. And what this meant is that the contractor was responsible for basically anything that was in the ground or any unknown subsurface or surface condition. It owned the ground. And what happened was, because of that huge risk that the contractor is taking on, contractors would often increase their bid prices or add a large contingency to their bid in order to cover that risk of taking on the differing site conditions and the subsurface conditions that they were going to encounter on a project site. And in response to that, owners, especially the government and public projects, didn't like the increased cost that they were receiving from these contractors in their bids. So they wanted to create a way to shift that risk onto themselves and eliminate the increased bid prices. And this is how the differing site condition clause came about. It came about for that various reason, to shift the risk from the contractor to the owner. And once a differing site condition clause was invented and included in contracts, this had the result of decreasing the bid prices, decreasing the contract amounts. So the owners, benefited from this. They benefited from a differing site condition clause by having lower contract amounts. And in many cases, on a project, they wouldn't encounter a differing site condition, so they wouldn't have to face that risk anyways. So that just gives a story about who bears the risk for a differing site condition. A differing site condition clause is prevalent nowadays. It's included in every federal construction project involving civil site work. It's specifically identified in FAR 52.236-2. A differing site condition clause is included in every state DOT project. It's going to be in the contract for every DOT project you come across. And the clauses are now very similar. There might be some differences in language here and there, but for the most part, the differing site condition clauses are very similar throughout. Now, in private contracts, it's a little bit distinct from the public arena. In private contracts, they're not necessarily in every civil site work private contract. And oftentimes, prime contractors and subcontractors have to negotiate for the inclusion of differing site conditions or include other language to protect themselves from the risk of differing site conditions. And I represent a lot of civil site work contractors, and I also take a look at their contracts before they enter into them. And you have to be very careful, because a lot of owner contracts will include very broad language that puts the risk of subsurface conditions on that contractor. And that's something that the contractors need to be look out for in a private contract. So as far as what the differing site condition of the FAR says, the very first part, it says the contractor shall promptly and before the conditions are disturbed give a written notice to the contracting officer of, number one, subsurface or latent physical conditions at the site which differ materially from those indicated in this contract, or number two, unknown physical conditions at the site of an unusual nature which differ materially from those ordinarily encountered and generally recognized as inherent in work of the character provided for in the contract. That's the FAR provision. So it establishes really a two-type differing site condition process that that a contractor must comply with. It must comply with either one of those two types in order to recover additional compensation or time. And this FAR provision also has a notice requirement. John was speaking earlier about notice requirements and how important they are. This is just a perfect example of that. The FAR provision has a notice requirement that requires a contractor to provide written notice of its discovery of a differing site condition before it disturbs the condition itself. A contractor has to comply with that, or else it risks waiving its claim. And so within a differing site condition clause, whether it's a FAR clause or a state DOT provision and requirement or a private job, you're going to see two types of differing site conditions. The type one, it has to be tied to the contract itself. There has to be some kind of contract representation that says this is the condition that's out there, or this is the condition that isn't out there. It has to be tied to the contract itself, and then the contractor can come in and say, well, when I was excavating or doing grading work in the subsurface conditions, I encountered a condition that was not as stated in the contract itself. A type 2 is different. A type 2 differing site condition is not tied to the contract. It is more appropriate that a contractor encounters a condition that is really not recognized in the area itself. So there may be a condition that he encounters in the subsurface materials that was never found in that county for some reason. That's more of a type 2 differing site conditions. Type 2 is much harder to prove. It's less frequent. A type 1 is more frequent, and it's easier to prove for a contractor if he can tie it back to the contract itself. Notice is very important. A contractor has to comply with the notice provisions under the FAR, or it'll waive its claim. And the federal law provides a little bit more leeway with notice than state law often does. And Virginia is very strict, as well as other states are very strict, that if you don't comply with written notice requirements, your claim is essentially gone. So a contractor has to be aware of that. As far as some real-world examples of differing site conditions, utilities, underground utilities that were not in the plans or specs is a common one. Unsuitable soils, if a contractor encounters soils that cannot be used as backfill or can't be used as bearing material for foundation or any other kind of facilities, that's a common one. Sometimes contractors encounter hazardous material. Rock is sometimes a differing site condition where the contractor was not expecting to hit rock and he has to blast it out. Sometimes a contractor encounters timber and concrete that was just covered over from a prior project. Those are just some examples of differing site conditions that occur in a subsurface sense for a civil site work contractor. For a type 1 differing site condition, for example, the above unforeseen conditions must be based upon a representation made in the contract documents. And to give you an example of that, let's say the project plans were incorporated into the contract, as they often are, and almost always are, and the plans represented that there would be no underground utilities in the subsurface conditions. But yet the contractor goes out there and in his excavation encounters underground utilities that he has to remove and replace at a significant cost. That is a prime example of a type 1 differing site condition that the contractor would be entitled to additional compensation and possibly time for. If the differing site condition cannot be tied to the contract, again, they must show that it's not typically found in that locality. That's a type 2. There's also different types of differing site condition. That the last example I gave with utilities was kind of an unexpected situation where the contract documents didn't expect any utilities. You can have a differing site condition that is based upon unforeseen quantities. So you can have a situation where the contract documents anticipate a certain quantity of unsuitable soils or a certain quantity of rock, but yet the contractor goes out and discovers that the amount of unsuitable soil on the project is far away more than what anticipated in the contract documents, and same for rock. So just to give an example of that, let's say a geotechnical report, which was again incorporated into the contract, represented that there would be 5,000 cubic yards of unsuitable soil, but the site work contractor, when he goes out on the job, finds that there's actually 12,000 cubic yards of unsuitable soil. It's going to cost that contractor a significant amount of money to remove and replace that unsuitable soil and basically take it off site. That would be an example of an increased quantities differing site condition that the contractor would be entitled to. And also, I think it's important to understand that a differing site condition will take precedence over a unit price payment provision and a variation in estimated quantities provision as well. So the contractor may be entitled to recover its actual cost, even though there was a unit price for unsuitable soils in its contract. Also, a type 1 differing site condition may include a different type of condition, not just increased quantities or an unexpected condition, but a different type. And an example of that is rock. Let's say that the geotechnical report anticipated that there would be weathered rock on the project that wouldn't require blasting, but in fact the contractor goes out and finds out that there is rock out there, but it's much harder and denser than anticipated, and now he has to spend money to blast it. The contractor would be able to make a claim for type 1 differing site condition in that one as well. And same thing with in situ soils that were encountered that could not be used as backfill for the specifications, or were used as bearing materials. A geotechnical report you will find is really intertwined with differing site condition issues. On most projects involving site work, a geotechnical report will be issued, and that is, a geotechnical report is an analysis of the subsurface conditions at the project site. Borings are taken at various locations to identify the subsurface conditions, and a geotechnical report is typically included and incorporated as a contract document itself, so it can be tied to a type 1 differing site condition. The problem with geotechnical reports, at least that is pretty frequent, is that it only identifies the subsurface conditions at the boring sites and not areas in between that. So that's usually where disputes arise as to what a contractor encountered out on the project site, which was unexpected. Oftentimes, owners will try to disclaim the geotechnical report itself. They will have language in their contracts which say that the contractor cannot rely upon anything or any representations in the geotechnical report. Oftentimes, the owners will also try to include a provision that the contractor must, visit the site and do a walkthrough to investigate the site. These disclaimers are not usually successful in defeating a contractor's type 1 differing site condition claim. And the reason for that is that the courts have found that it's unreasonable for an owner to include a differing site condition clause in its contract, which says I'm taking the risk on for unforeseen differing site conditions, based upon a contract representation, but at the same time include a disclaimer which says, well, you can't rely upon my contract representation. So the disclaimers are not very successful in a type 1 scenario. What kind of damages exist? Well, if proven, a contractor is entitled to its cost of removing and remediating a different site condition. Contractors are also entitled to delay damage to the extent they can prove up that the differing site condition caused a delay to the project site. And as John talked about earlier, contractors must comply with the notice provisions in the differing site conditions to recover those kind of damages. And I will say lastly on the differing site condition, and I'll hand it back over to John, which is I think it's important for contractors to train their project staff to be aware of what the scope of work is, so that when they encounter a differing site condition on the site, they can become aware of it. And they can also pass it up a chain, pass the notice up, and make their superiors aware